And we're live. Hi, everybody. Welcome to the third installment of this kind of collaborative hack with Brendan Marr and with Beth McCarthy of the Mechanism Design Group, and also Brian Wilson, among others, we've been collaborating to co-organize this series of kind of deep dives against scenarios with automated legal entities. And so this session is being hosted by the Mechanism Design Group and being kind of convened by Beth and her team in Berlin. So I just want to pass. Oh, my name is Dazza Greenwood. I'm here at the Media Lab, and we're holding down, one of the stakes as a collaborator. But this is the Mechanism Design Show today. So I want to hand it off to Beth to sort of set it up and to help run the meeting. So thanks, Beth, and take it away.
Yeah, so I guess if people have the HackMD open, then we'll talk a little bit about the kind of methodology we're going to use. So in the past two calls, then, we started with this idea of there being, applying agent principle law as a framework for examining kind of power differentials in relationships and who owes, fiduciary duty to one another in different situations when rights and responsibilities flow between entities, et cetera. So we could extrapolate those ideas to creating frameworks for DAOs. So last time, as everyone remembers, we took our example of engaging with a physical book being shared between parties to a DAO use case where we walked through the DAO as agent and principal. And now we're ready to take that a step further in two ways. Number one, walking through a book use case where a DAO is acting as agent, principal, and third party, and specifically with a real life DAO example that Jim has made. So he'll tell a little bit about that, maybe to start out, but quickly about the workflow we're going to do. So if you look on the HackMD, then there's this publishing DAO diagram that can be viewed as the certain functions that flow between entities that are marked in a circle and like autonomous processes that are marked in a square. So what we're going to do is walk through each of those DAO functions through the lens of how the function presents as a transaction that is actually performed by the DAO, and that is filling in this matrix that kind of maps onto it, and this will start to make some more sense as we're going through it, using the fact pattern narrative we made with different permutations for what can happen, the same as we've been doing. So we'll use this agency transaction table to which kind of riffing off of what Chris has shared with this idea of using a matrix as a way to go through and view these different permutations. So we'll fill out for that who is the agent, the principal, and the third party, and how those different configurations impact the outcome, and we will use that then to look at this agency outcomes map that we made that is at the very bottom here, that is a way of saying this is how in these different kind of like legacy system archetypes that we have in America of like, an incorporated company, a BBLLC, an LLC, and a general partnership, how, this analysis would play out differently based on the different like parameters that set those apart from one another. Because we talked a little bit last time about two different types of DAO archetypes, a DAO hub or the DAO archetype, which is, this kind of nebulous network of participants that, is minimally self-regulating and, was not trying to be in a configuration that, matched an American legacy system, and a deorg type of DAO, which is, officially architected as a BBLLC and subject to, these particular parameters. And then I think what will start to emerge by the end of today is another additional DAO archetype that we can kind of use in this analysis, which is this, DAO that is coming together to perform a specific function for external parties and also for itself. So, yeah. I think to get started, if you want to kind of introduce about the publishing DAO, maybe that would be.
Yeah, I think you said it best. I mean, it's like taking the functions of a publisher and seeing how can we decentralize such functions, like being able to invest in a fixed cost asset and enjoying the fruits of this asset and interacting with the public as with sales and with proposals. And yeah, this model is trying to capture how those functions can be done in a decentralized manner. And I think it can serve as, like if you run through this like law of agency lens through this diagram, then you can actually see how complex the situation can get, because the roles start becoming very granular and complicated. But I think it's a good starting point to just see where are the bottlenecks, where we can kind of condense things into the existing legal framework, or where there's need for new perspective to adapt to looking at these decentralized organizations occupying like functional roles in the real economy and so on. So, and yeah, one other thing is that like every little function here can be customized to like a plethora of combinations, and they can usually have like situation changing consequences, as like one little change would like make something compliant or uncompliant, or create a conflict or avoid a conflict by its configuration pattern. So
I'm on my screen.
That's just to say that like things are extremely complex on a mechanism design level. So you want to start with the narrative?
Yeah, so maybe if you want to just walk me through.
So we kind of came up with these like traditional like law school fact patterns to demonstrate some of these bottlenecks can emerge, and these kind of unique confluences that exist because it's like entering in a new way, like a paradigm that's more technically enabled than something that was designed for the like paradigm of paper. And so we came up with this sort of Dallas and Bob example, and so I'll just read through. And then once we get through that, we've got some instructions about kind of like how we can start to process this, how we can start to understand more of the nuance, and really break down and understand what the different roles are here. So we have an aspiring poet of the revolution named Bob, who's seeking to print a limited edition collection of some original poems for donors at this Poetry as Resistance Festival. Bob requests that Dallas, the publishing DAO, produce 25 physical copies of the book to distribute before the festival begins on August 31st. His proposal is accompanied by a deposit, a standard precaution for Dallas, so that it is able to avoid spam attacks. In June, Dallas receives Bob's proposal to publish the book. Reception of the request starts. Dallas's procedure for the book publication, which is comprised of the following: a panel of DAO curators who are voting eligible members review the proposal and vote via DAO's voting app on whether the approval of the proposal should go through. So that's basically, making sure that this is a book that the publishing DAO actually wants to publish. So it's like one of the core business functions. I think so. So the book is either approved or rejected by the curators of the DAO based on whatever the consensus is. If the book is approved, it moves to the next step. If it's rejected, the deposit's claimed by the DAO, and Bob doesn't recoup any of it. And so this, and then the next step being the espresso book machine, which is kind of like the automated way to produce these books, will print the correct number of copies of the book, and then logistic partners like Charlie Corp are hired to ship the book and distribute the copies to the appropriate recipients. And so, jumping ahead of the table, like the first fact pattern that we have is this one where nothing goes wrong. So Bob submits a manuscript of the entirely original work, devoid of any illegal content or activity. The transaction executes as expected. The espresso book machine prints the complete versions of Bob's book in the requested amount without any IP violations. The logistic partners then deliver the book on time. And so for this one, we mapped it out a little bit at the top of the transaction table where we have, this is permutation A, the member of the public funds that out, the third party produced the book. And in this case, the member would be, or the principal would be the member of the public, the agent would be the DAO, and the third party would be the publishing house. And so in this case, everything actually works the way that it was intended. And so we don't run into any issues. In permutation B, things start to get a little crazy though. Bob includes a poem that, when read backwards, contains classified information about a new spying program protected against by national security regulations. None of the curators realize the secret information is included. And so in this case, we wanted to see, because this is functioning as a DAO, how are we going to start ascribing the liability? And so I'll open it up there for some discussion, and then we can start filling in the blanks based on how the discussion's flowing.
Yeah, so I just thought of a way to possibly make this more clear. Yeah, does anyone have any thoughts?
So let me see. I guess just to make sure I've got it. So in permutation B, so the parties are, let's see, the logistics partner. How many parties are there, and what are their roles? Let's start with that.
So if you look at the if you look at the publishing DAO workflow diagram,
Okay.
That's the one listed at the top. We have all of the different roles identified with the circles, and then we have all the automated processes indicated with the rectangles, and then we kind of have you're able to visually see the flow from one party to another of how this kind of transaction is taking place throughout these different permutations.
So I have a question about I can imagine well enough what's the legal form of the logistic partners or people in the public or authors, but to me it's not clear what the espresso book machine legal status is. Is it owned by a company? Is it self-owned through a DAO? That's pretty relevant to defining what the parties are.
Yes, and you'd be better able to answer that than I would.
Yeah, so it's actually designed as owned by the DAO, but of course I do not have any type of legal specification while I was drawing this stuff. So I don't know if legally how does the ownership of espresso book machine interfacing with the legal system works within this context. So, but it's purchased through a bonding curve.
Yeah, so it would be.
It's a tokenized.
Yeah. Okay.
You fit it in your legal system.
So it's like a security offer STO, which is tokenized, and the tokens are held by the DAO.
It's probably avoiding to be that.
Nobody talks about security.
It's not security. It's a subscription model.
No, but nobody is selling tokens of the pre-buying machines and then selling them. There's no treatment of the machines. Just people buying a machine and getting it on the DAO.
100% of the machine is somehow owned by the DAO, which
Yes.
might be whatever.
Somehow it can be a donation. It could be the DAO buys it from a legal entity that had it before. Maybe it buys it from the website of the special machine.
And here we come to the question of how did the DAO by is
Yeah.
it one LLC or is it like a general partnership or is it nothing? Is it
Is it
just
just a
like a
DAO?
contractual relationship? Like how did you actually get to hold the machine? But that's a different question.
Yeah, or is there an agent in between that does the purchasing?
Yeah, like one of the logistics people is somebody who deals with the logistics of the book machine.
Okay, so just to kind of go with what you said so far, looking at the the diagram for the publishing DAO, it seems like for the scenario A and the permutation in B, there's member of the public. Okay, so the publishing DAO, at some point there should be an arrow from the publishing DAO pointing to the author, requisitioning basically. No, okay, well, who starts the sequence? Like somebody asks that there be a book published for Bob, and then somebody approves it, and then somebody basically tasks the logistics to create the book. So can you just run through that pattern so we can see, because the arrows don't reflect that right now.
So
Yeah, what's the question is what is the order? What's the starting point?
So yeah, so from the starting point, like so from the background beneath the publishing DAO diagram, we have our starting point as Bob, who's seeking to print the collection of poems. So
what circle does Bob belong to?
he's a member of the public.
Okay.
And so from member of the public, he submits the proposal. The proposal, like he has to stake a certain amount of funds in order to prevent the publishing DAO from being spammed. And depending on whether those funds are, or depending on whether the proposal is accepted or rejected, the funds are either deposited directly into the DAO if it fails, and they are transferred to the the Espresso book machine as like a down payment on like the production run that he has.
So just to double check, Bob is in the member of the public circle.
Yeah.
But he's also an author, but he's not in the author circle.
So the author circle on the right is a little bit different. These are for the members of the publishing DAO.
But hypothetically, it can be another scenario in which, like, Bob is an author that got onboarded to the DAO, and then he's proposing to the DAO from inside without paying.
Yeah, because there's a major distinction that we just tried to do the simplest version of it, which is somebody can join the DAO themselves and publish from within the DAO, but that is one of the factors that would change it, because then the DAO would become a principal because somebody from within the DAO would be doing it. So in order to keep the agent as a third party that is getting published through, then Bob he stays as a member of the public. He doesn't become an author that exists within the DAO.
But I would say that actually the member of the public is just people who can propose, and then the author, editor, curator are people who already proposed in the past, and they get given a token. Yeah, they're part of the guild or the cooperative, and you could set in advance saying like, every time you become an author, you get 200 tokens, or every book is 200 tokens that the people who are making this book, whatever their role is in making that book, they get a certain amount of token, and then they're inside the community.
But they don't need necessarily to propose anything, because like onboarding is also about like having a distinguished community of curators that know a certain subject, so they can understand if this is publishing worthy, or like, you know, maybe it's a legal journal, and you have to have the people that are authorities in their field.
So for example, one example, so in the DX-DAO, like anyone can make a proposal. So there's no onboarding for proposal makers. It's just
Also
like
here also the public can make proposal, but these guys have the voting power on the proposals, just like you have.
But the twist is on what you said about like it becoming an agency. That's not necessarily true, because the author could be an DAO, so it doesn't confer personhood necessarily.
So what I meant was agent in the definition of like whether it's an agent versus a principal, because we're going through the matrix with like the DAO as a agent, and what I mean by agent is like, you know, Bob, like they're producing something on behalf of Bob.
Mm-hmm.
You know
what if
I
you're
mean?
on both sides?
That is possible, but just not for the constraints of the narrative.
So for us, we're now looking at the DAO as an agent, not as a principal.
Yeah, so just for right now, and because otherwise it was, I mean, but in different parts of the scenario, then parts of that might change around. But like for the sake of this, Bob is not part of the DAO. He is not operating from within the DAO. He's an external force that the DAO is operating, by proxy for him.
So basically,
yeah, because that is
So
definitely
Bob is the principal, basically, and the author. He kind of basically submits to the DAO, saying, "Hey, I want to publish through your DAO." The DAO approves it, and then basically hires the logistics partner to do the publishing and distribution. Is that the basics of it?
Yes, I mean, we can go even more decentralized than that the DAO creates a bounty that, like, if you deliver this thing, like, it can also be on that level
it can be commissioned.
decentralized, and the third party becomes like a bounty hunter in crypto terms.
So we could do that, but I mean, just for purposes of working through on one scenario, is what I just said what we're working through, or do we want to do the bounty thing?
no, it's what you
I don't know, it's definitely what you're talking about. It's just that, like, I want to, like, what I said in the beginning, that, like, if you tweak just a little parameter, again, like, you can go on to different layers of complexity. But yeah,
Okay, that's good to know. It's a robust system.
totally.
At least for legal analysis, you can't ever really know a legal outcome unless you apply the law to facts. So we kind of have to at least lock down some examples for this.
Well, hopefully we laid that out in the narrative.
Okay, so then what happens in permutation B is it turns out there's something illegal in the book, and the book is basically like contraband because it's a state secret and violates some kind of security law. Is that the idea?
Yeah, so basically,
I just said yes.
Yeah, so basically, Bob, who is not part of the DAO, he's not there, right? Bob, who is the principal,
Sorry, I still don't understand why Bob is the principal. If you're working for the DAO, I mean, maybe he is, but what is the justification that Bob is the principal here?
Because Bob is like the person who instructs the DAO to do a certain thing.
No, the DAO is paying him to make a book.
Man.
He wants the run of his books. Like, he wants the run of his books to be published. And so in order to have those books published, he enters into a contractual arrangement whereby the DAO publishes his books for him and then takes care of those logistical.
Yeah, so
Okay,
to
it's
run,
not like a process where he proposed, I'm going to make a book, and then the DAO funds
no.
it.
So to run back through the fact pattern, kind of, basically, Bob is this poet. There's people who donated to his poetry festival. He wants to print 25 books to distribute to the donors of the festival as a thank you gift, and also to promote his poetry. He chooses, instead of another small press option, to have this book be printed by the espresso book machine. So the DAO is just performing the function for him of printing and shipping his book. So I guess that's kind of where we're at. So in Permutation A, then he submits entirely original poems that have nothing illegal in them. It's not pirated.
So what is the
anything.
proposal process about? What do the members of the DAO vote on?
So the thing the members vote on is whether or not his proposal will pass, which his proposal is to get his manuscript printed by the book
Is it a proposal?
machine.
It's a commission, because that changes the nature of the
Yeah,
relationship.
they create according to if this DAO is for example, eligible for printing political content. Maybe they are an architecture journal, has nothing to do with
So it's will we accept this person?
Exactly.
It's not allocating funds to
No, so we basically left, just to be very clear, we left out the fund allocation part to keep it simple. So he has the funds from somewhere else. He's providing all the funds and just paying the DAO. The function the DAO is doing is using the espresso book machine to print a thing for him.
So curating the
Yeah.
So the DAO really uses the service provider mostly.
In this particular
in this
example.
particular example. But if for example, someone from the inside of the DAO would be the proposer, then they could fund it with DAO's own funds, which is what you
and then it becomes not the principal Bob, but he would be the agent of the DAO.
Yeah,
He's being commissioned by the DAO to write a book. Or
if he was commissioned, he would be the agent.
And another thing, another situation that could happen is, he could make a proposal for the DAO to help him with the fundraising process. In this case, he has the money to print this book from somewhere else. It's from the donor. So external people gave him money. He's using that external money, you know, all at once. Like, you know, he made in order to stake into, like, you know, having this vote happen at all, he like made a deposit. But then in order for the book, you know, once they vote to approve that they're going to print his book, then he has to pay the entire rest of the money that he has. They're not using the fund, like the market manager thing.
I had a question and a
Yes.
statement. So because it's not printing names, who would the person be to Silke's right?
What?
Oh,
I'm right.
who-
I'm always right.
Me, Clem. Or
Okay.
Clem, or Clem as so.
Oh, my Clem. Okay, great. I couldn't tell for sure. You know, great to see you. we talk so much, but you know, a video is worth a billion words, right? And so this statement, I think, to give clarity, is, and to answer the question, is Bob is the principal because Bob initiates the transaction with the agent, which is the DAO.
Yeah.
That's my understanding.
Sort of initiate, but the key thing in agency law is that the principal and the agent agree with each other that the agent will do something on the principal's behalf. And will act as basically as like the servant of the principal for this task.
Yes.
It seems like that's a little bit of a stretch for the intended general operation of the publishing now. So I'm glad that we're able to suspend disbelief that this is usually probably not how it would go with the DAO, but at least so we can run on training wheels first and then build the complexity up.
Definitely, because there's some really, like, it can get like really crazy, like so quickly that it would be hard to have like a structured discussion where you went through each of the things. So, you know, this is just the most simple situation that we can think of.
So the question that you usually ask at the end of these is what are the rights and responsibilities of each party, the other one, when the thing blows up? So to represent the fact that the thing blew up, you get a cease and desist letter from the National Security Agency or you know, the equivalent agency of your country where most of the people are, where Bob is, or where the machine is that's publishing or whatever. And then the question is, okay, now what happens? And so, like, let's just say hypothetically to make it clear that that in this country under this law they have a fine and they assess a fine of $1 million for this violation. And now people are wondering, like, okay, now we get into sort of like almost a quasi litigation or a mediation context, and people are trying to throw the hot potato to the other party, saying, "Well, I shouldn't have to pay. It should be the espresso machine, or I shouldn't have to pay. It should be someone else." And defenses of each party in terms of ultimate liability for this massive screw up.
Well, I would argue that it's about where the machine is located, because if the machine is printing, say, in Germany, where it's not subject to that regulation, then there won't be a problem. But if it's printing the machine in the US, then it is contravening the law, and it's not the people in the DAO who might be, you know, in Mongolia or in, you know, Indonesia or somewhere to be responsible for what the EBM is doing in America, right?
Perhaps. So is the circle that says logistics partner, they're the ones that operate and basically own the machine, or no?
The DAO owns the machine in this example.
Yeah, the DAO owns the machine in this example. The espresso book machine is kind of like this automated function, basically, that the DAO has subsidized through whatever means they came into ownership of it with. The logistics partners are more so the people who, once the book is once the book is printed and there's like a run of, you know, the 25 books or however many, the logistics partner is the one responsible for getting the books from the espresso book machine to Bob, who requested the 25 copies for his event.
So distribution. Okay, so then the question would be, if in order to have a circle from a legal perspective, unlike a technical diagram, like in this case, the circle represents a party, and a party is a legal entity that can sue and be sued. Like that's the whole point of it. According to Oliver Goodenough's analysis, if there's nothing else that's happened, such as creating an LLC or some other legal form that would hold up, then the default analysis is you have a general partnership. So every member of that circle would be jointly and severally liable for the actions that happened. So if they're the ones that own the espresso machine, and just to go with what Ken was saying, that's the jurisdiction where the heat's coming down from the security agency and they just assessed a fine, then I mean, I'm not a litigator, but I would imagine that people would start wondering, is there anybody that's a member of this DAO who has like locus or nexus with that jurisdiction? Like, do they have a house there? Do they live there? Can we get our hands on them? And you could start basically subpoenaing those people because they're all jointly and severally liable. Or are there any other assets at all? But then to kick it up a notch, though, if you imagine that it has legal personality, which is kind of the idea of the legal entity part of the AALE, then you ask the question, well, what legal personality does it have? Is it a corporation, an LLC, a nonprofit, some other form? And then you could ask, why do you think it is this legal entity? Like, is there a jurisdiction that's granted it? Or is there some other reason why a court would ascribe legal entity-ness to it? So how about those questions?
Sure. So I think we get to the point that you were just at with like really drilling down on the type of entity that's involved, the type of issue that's involved, and the specific outcomes that are correlated with that point in kind of this agency outcome scenario tracker. And that's where we wanted to, and this is kind of like where we were building to, but I think it makes sense to like jump a little bit ahead so that it helps provide like the depth of context there. But for each of these different entity types, it's foreseeable, that we can start plugging in some of the work that Chris has thrown into the matrices for what happens with the automated autonomous legal entities. We can start building that into kind of this framework where we look at it under the lens of a general partnership, under the lens of an LLC, under the lens of a BVLLC, under the lens of a corporation, and look at not only the analysis for if it's just like this traditional situation, but also the analysis if it's a DAO that's involved, and start comparing and contrasting and understanding what those patterns are between like what happens if it's a DAO and what happens if it's a human or a set of humans who've just kind of done this without any kind of technological assistance. It's just the kind of paper paradigm there. And so I think by walking through the transaction table, the agency transaction table, and identifying these people, identifying what happens when things go wrong, and identifying what those roles and responsibilities are, we can then start going through the agency outcome sheet and populating it with the relevant information that we've extracted.
Do you want to just, if it's not too disruptive, do you want to quickly run through permutation B and just see what would the outcome be?
Sure, and I'm gonna share my screen because it has the interactive version. I've only included the PDF there. I can upload the XMind file itself once it gets to after this call.
So just a quick note on the diagram that is on, I guess, Beth's screen, the binding assent part, I think kind of speaks to, is there an agency relationship? Like, was there that agreement that is enforceable that some principal and some agent agreed, hey, I'll be the agent for you and do this thing. So that's kind of what's caught up in that. Okay, oh, you've got it. So I'm going to go on mute.
This is going to be tricky. I need the screen so I can see the. Or could you just pull up the fact pattern? Okay. Yeah, and so we can walk through the fact pattern. Which permutation were we going through?
B.
B. Okay. So the curators review the content, pass and vote on the approval proposal, or they pass it. The vote passes and they approve the proposal. Sorry. And then when read backwards, it contains the classified information. So the questions are like, what happens when this goes wrong, and like which roles are responsible. And I think in this example, there would probably be some duty of the publishing DAO, since it's meant to like kind of curate like the content that's coming through there, ensure that nothing bad is happening. That they would have some duty to not publish information if the NSA or whoever starts coming after them with the information that they have.
Isn't it also dependent on where you're based?
Yes, it would affect the ability for them to like reach you. So even if it was like if it was somewhere that was incorporated, I don't know.
Well, so wouldn't it also impact the knowledge? Because, it's like none of the curators realize that this is included. Like, is it something where they would have more duty of care to like know that if it's in their country? Like,
I would even go more forward to like a permutation C, where like or D, I don't know what it is, where they know it's illegal. You have to take into account that we're talking about publishing here. So let's say WikiLeaks would like commission them to print, Hillary Clinton's emails, let's say, or the war files in Iraq. It would be illegal, even talking about the U.S. Like it would be illegal for WikiLeaks to get that information, but a newspaper, even like a centralized entity, has the right to make that information publicly available. And that was like the whole question about like the Daniel Ellsberg, the Pentagon Papers, and whatnot about like the legality of freedom of information. I think we should also take into account not just like principal agent law, but also like freedom of information within like publishing.
Yeah,
definitely.
That's a very good point.
Okay, so where this is a little ambiguous and that makes it's tripping me up a little bit to think about a legal analysis is you've got general partnership up top, and then you have principal third-party agent, but the kind of the relevant aspect of the scenario in order to run a legal analysis is which of the parties is a DAO. So you want to say that, and then what is the general partnership? So it seems like in this particular scenario, just to lock it down, you've got a principal who is a single human being named Bob. You have an agent that is a DAO, that is a general partnership, and you've got and I don't see who the third party is.
I think that what also is important, and that's just me talking my private international law stuff here. Is basically we need to know where which jurisdiction we are looking at, which national security agents' intelligence was breached. Because then, of course, it also depends on the laws of that jurisdiction on the publishing. So I think we need to like kind of specify more like where each of the things are located, and to make it complicated is to make a DAO basically.
Definitely.
Yep.
Well, okay, so based on that, I'm wondering if we should move to Permutation C, where we do specify more details.
Okay.
And talking about a combination of those, because for Permutation B, the thing we were trying to get at was like, this idea that if there's illegal information somehow in a book, but the people who are approving the existence of this book don't realize it's illegal, or, in general, that like the DAO is publishing this illegal thing, then, you could be like, it's a photo book of child porn or something like that. Like the point of that is, twofold. Like number one, is it legal in all the possible jurisdictions as we were talking about? And then also, not to get too hung up on those details. So kind of to talk about Permutation C, and then I think it could be really useful to talk about, is there a difference with whether the content is illegal in an intellectual property way versus like violating a regulation. So, for Permutation C, as it turns out, several of the poems in the book are verbatim copies of poems by Allen Ginsberg. They're part of the Ginsberg estate and unavailable through the public domain, i.e. the poems are pirated, because we had to figure out how a physical book would be pirated. None of the curators who voted to approve the proposal realized that the poems weren't all original. In fact, most of them didn't review the content of the book at all. Most of the no votes, one of the no votes did come from a curator who noticed that the poems were very similar to Ginsberg and looked up the original poem to confirm it, but didn't share that information with the other voters. So, to compare between Permutation B and C, then in both scenarios, there was an illegal aspect. The proposal passed regardless. All the curators who voted yes to pass the approval were ignorant as to whether, and ignorant to the fact that they were illegal. But, here, hopefully, my computer's offline. Oh, weird. Okay, I don't know. Hopefully you can still see my screen because it says offline.
Yep, we can see it.
What?
We can see it.
Oh, good. Okay. So I don't know if that kind of shed some light on kind of what we were thinking, or if it would be useful to go through C and then revisit B in relation to it, or.
Okay. So it seems like in essence, it's kind of like, it's sort of like the same thing where there's something illegal or liability attracting about the content of the book, but in this case it's IP and not violation of some state secret, right?
Yes.
Okay. So one thing that's interesting that I'm just kind of spitballing here, but the reason why agency law is so interesting as opposed to contract law or tort or something for looking at these relationships is when you've got an agent that's operating on behalf of a principal, and that's and that is like a valid relationship. The principal is at least under U.S. law, and so Silke and others, please pipe in if it's different. There's a standard that says the principal is held to know everything that the agent knows, and so there's like a constructive knowledge. So if the agent's aware of something, the principal is held to be aware of that thing too. So the agent's acting as the principal, which means that the agent damn well better tell the principal things that they become aware of, like the property you're buying is on toxic waste or whatever they know. The principal is held to know that. So if in this case the agent is the publishing is the DAO, and the principal is Bob, and for whatever reason Bob is unaware that his stuff violates IP, but one of the agents is aware, it may raise a question of whether they drag Bob down. Because of the specific facts, it seems quite likely that since Bob was the originator of the material, that Bob, I guess in the ordinary course, I'd assume Bob would be well aware of what Bob did. And so the question then becomes, can you attribute the knowledge of this one agent to the other agents, somehow? Did they all become tainted with the knowledge that there was a violation somehow? With IP, it's really complicated. I usually stay away from IP, but there's other issues with contributory, violation of IP where, just the mere fact that you're doing it, even without knowledge, can create some liability. And, there's a whole tangled web of IP law that I think we need to not get into in order to just look at the general liability flows between parties just at a high level when something goes wrong. But those are some just super high level musings on Permutation C.
Yeah, well, one question about that, and maybe this is what you were hitting on, is, we included this thing of the curators didn't know that they were contributing, the curators who voted to pass it at all didn't realize that they were doing that. And, the one person that did realize this, wasn't involved in pushing the actual transaction itself that kind of pushed the causal chain forward. So what I was kind of trying to get at there, and something, that we had talked about and wanted to try to, touch on with the fact pattern is the extent to which the corporate veil happens with like happens with DAOs, and like in particular, like whether the different people in the DAO are all considered on equal footing as entities within the DAO, or if only voting members, since, you know, going back to the diagram where, you know, there's like autonomous processes and then there's like the human in the loop that happens, like if, so it's basically like, you know, the process is only pushed forward by, you know, the actions that are taken of voting. And so if the action that, and you know, if the action that happens such, you know, that the book is actually published is only pushed forward by individuals that didn't realize that they were doing something wrong, then does the opinion or, you know, the level of knowledge of someone who did know they were doing something wrong, like does that have any impact? Like liability piercing?
Yep.
That's a good point, right?
Jurisdiction.
Yeah.
What did you say, Silky?
I said it depends on the jurisdiction.
How so? Like, how would it be different from one to another?
No, I mean the question as to, if I understand correctly, the question on whether the third party would be liable or the agent would be liable for doing something on laws of agency. No?
Could you say that again and speak closer to the mics, okay?
Yeah, we couldn't really hear you.
So what I'm trying to say is that, and I might be wrong because I haven't been in the last two sessions on this. The question as to what liability attaches to the agent for, you know, doing something that is wrong on behalf of the principal depends on the national agency law that the relationship is governed by.
I may be way off base here, but I thought most of the basic principles of agency law were identical across, you know, like developed nations. No.
But I think I don't know what the status is under American law. Wouldn't it be like or any American law? Wouldn't it be that if the agent actually had no, I mean, depending on what status as an agent he had, and whether, you know, wouldn't it be like he's not liable for whatever the principal did and he didn't know, unless it must be reasonable, or is that not a concept? I mean, I think and I'm not entirely sure, but I assume that under UK law it would be depending on whether the person, that's reasonable to assume that. But and I'm sorry to interject here because I don't know the status of American agency.
That's okay.
Yeah. Well, I mean, the entire point of this is to try, like, we were trying to find something that would like cut across as many jurisdictions as possible, because, you know, with contract law, with all the ways that we've been thinking about this, then, you know, it depends were like too frequent, you know, torts, etc. But then with agency law, from our understanding, then it was like, hopefully something that could be looked at as like an abstraction to a certain extent without like having to start from jurisdiction to the same extent. Like obviously that's always like one of the original, like one of the primitives that you have to start with, but that's not true.
We kind of did a sort of a conceit for the first two sessions, Silky, which was we looked at what we call the restatement of restatement of agency third, which is very much a United States, you know, kind of legal codification, which I think is largely similar, but we actually did lock it down basically in US law so that we could resolve some of the unknowable ambiguities in terms of what jurisdiction would it be and just isolate what a legal outcome would be, at least in one set of circumstances. But since this meeting is being hosted in Berlin, I feel like we can't really do that. Like that would be really wrong.
You know, I think it makes it easier to basically say that, you know, the party that is unhappy about the print must be based in the United States somewhere, because otherwise, you know, you need to deal with another agency law. Because, and also we assume that the relationship that printing machine would
yeah.
be in the United States.
And at least for this example, Allen Ginsberg's
Maybe that is-
estate
yeah.
is in the United States. So it probably, if they're being, sued or whatever by like Allen Ginsberg estate, in the fact pattern of permutation
That's
C.
not so the state is in the United States. So
Yeah. So at least, sorry about the U.S. central way of framing this, because I guess it was made.
Sokka, but Sokka, that's the point of all this. The point of all this, Sokka, is to break the global legal system, right?
yeah, I think we should. But let's write a standard global agency law.
Yes.
I would actually not want an agency law. I want a DAO law.
Yes, the crypto jurisdiction is.
What about,
impending.
does somebody have a reminder on the Roman principle, like the horse that is owned by nobody, and then like a story like that? No, like what happens when a horse that's not, you don't know the owner, but the horse like kills someone, and kind of like forfeited as a deal then, no?
My ability in Roman law is not very good. How about you, Beth?
Yes, thinking back to my prior life in ancient Rome, it was 3,000 years ago. I think, so that goes to another thing that we had talked about a lot and then decided was probably like a rabbit hole that we didn't want to go too far down, but the fact that, there's this distinction between code being, and obviously you know more about this than me because I think I learned about it from you at Koala, but, the fact that code is like this force, the author of it isn't liable, unlike, writing, then the person who wrote something is like, from our understanding, liable for the outcomes of something. So for example, if in the original configuration for this, poem that contains information about a spy agency, we have been thinking about if it was like contained, a recipe for building a bomb, and like what would be the difference for like, if there was an inclusion of like, here's the code for how to build a bomb versus like, here's, a natural language description of how to build a bomb. Like the fact that the actual code like is able to be this autonomous force that doesn't have liability, and the liability doesn't go back to an entity, therefore it probably wouldn't go back to a DAO. So like, there's this issue of like, number one, a choice of like how much you would encode versus having in language, because, the liability would flow differently. So I don't know if the horse example is like analogous to what we're saying with code here.
I mean, you're right, but I don't know if it's about the liability. You don't have liability when you write code. It's about, I think, code is free speech.
But that is again, on something.
Yeah,
and
exactly.
Again,
So in
there are
America,
they're great. Again, questions on this being still the case, whether the code should have like you should do this, whatever. That's different.
Well, this is a very interesting thought, because code is code, but code that's executed is something else.
Is it law? Just kidding.
So
code is law. No, I'm just joking. I was like, if code is executed, is that at the point that it becomes code is law? I mean, but maybe yes. he ran away.
Could you extrapolate on that, Brendan? Like, what are you talking about?
Well, I can have code, in any kind of I can have code in any kind of representation, right? In any language, in assembly, however you want to represent the flow of logic, right? I mean, it can even be in text. It can be human readable, right? But just because you have code, if it is not executing in a machine, right, then it just code sitting on my hard drive is not necessarily an evil thing.
Right.
But if I have code, that describes how to make, detonate a bomb, and it's just sitting there and it's not executing, well, how bad is it? It may be very bad. But if you have that same code and it is executing and it is doing the function, right, well, then it's probably very bad. So there's a difference between clearly things that are executable and things that are not, even if they're logical.
And then there are self-executing functions, which are not operated by the let's say, a creator of the code, but are maybe even like days or multiple parties down the line that it becomes executed and it causes some sort of damage or something like that. But still, the creator of that has almost nothing to do with it in terms of like he doesn't host the server, he doesn't like it's just a smart contract that executes itself according to the configuration that he had set for it.
But someone coded it to be that way, right?
But if it's a DAO.
Okay, so because
Yeah, anonymous DAO, what do you do then?
okay, so I think I might like cap this rabbit hole because we want to try to finish as close to the hour as possible, and I think we're like halfway through the use cases. So, but definitely interested in revisiting that in the chat and in general, because I really think in terms of which things are like actually pressing questions for issues that will arise when hopefully this becomes something we're testing in the wild, then that's going to be a major one. So. Or we could go deeper into discussing that thread and take discussion to the permutations like D through F to a future time, or just asynchronously. So which would y'all rather do?
More use cases.
Okay.
All right.
So permutate, and then also just how we had been like, should we go through the agency outcomes map, which is the thing that Brian was showing at the very bottom that, is very fun, but is also like guaranteed rabbit hole. So there's, the question of if we should do that or if we should continue through the, wait, I pressed something weird, sorry. Yeah, if we should go through that, or if we should go just save any discussion for that for the very end. So I think, if y'all, I love talking about it, and it's also the beginning of this diagramming framework that we hope to start introducing. But moving ahead to Permutation E, only talking about this agency transaction grid here and not yet referring to the agency outcome map. So Permutation E, the request has been approved to print the book. The request has been, Bob has made his proposal request to get the book printed. The DAO curators are deliberating for too long about whether they should print the book. Like, he made the request and the book needs to be printed by August 31st. He made the request, right now. Like, there would have been enough time if it was instantly approved, but some of them think that the content sucks, so they don't want it to be affiliated with their co-branding. Yes.
But what is the contractual relationship with it? Are there terms used for the DAO which say you have to look at a proposal with not materials?
Yeah, I think we intentionally left that open in case any of those change. So the only facts that we have are, the DAO curators take so long in reviewing the book that by the time the deliberation is happening, it won't be printed in time for the delivery to the, in time for the festival. And, shit, I forgot that I'm not on screen sharing. 1 second. So, to go back to how this permutation D plugs in here, in terms of the authorized DAO functions, this is the DAO function of, logistics. Curators review proposal, logistics company ships,
And then it prints the books with the EBM too.
And also onboarding because, as Sokka was mentioning, then what Bob is actually contractually agreeing to, would be covered in onboarding. So it's kind of if there's this question of what who knows what. So to make sure that we refer back to this chart, maybe if you wanted to walk us through how this one would play out with the flow chart.
I was just about to.
Oh, sorry. So it's permutation D.
I thought it was
E. Sorry. Oh, I accidentally skipped one, but it doesn't matter. We can go back to D.
Well, let's just go back to
Yeah, no, that's what I said. D.
That isn't simply you can put a timeout. I mean, that it's not really
Huh? Right.
like I would.
I accidentally skipped D, so we'll do it after, but we're just doing E right now.
So I would say that, I mean, since like the DAOs, like I would say that the contract is signed between the agent and the principal once the DAO approves or disapproves the proposal.
Yeah.
So that here you wouldn't have entered into an agreement, so you just polish.
Yeah.
Yeah,
Yeah.
Right.
So it's his problem that, they didn't enter into the agreement, and, it's a failure point that doesn't have a legal implication unless it's built into the contract. So, we wanted to include this one because that's where contract law, intersects with agency law, and, smart contracts need to be constructed in such a way that makes sense. So, permutation D.
Just to check, in permutation D, the principal is Bob still? Or who's the principal, who's the agent, and who's the third party in D?
Oh yeah, sorry. I thought we finished E.
Or okay, well, which one are we on now?
And the one we just talked about, which is E. Then,
I meant to say E. Excuse me. In E, when there's a failure with the delivery because it took too long, who's the principal, who's the agent, and who's the third party?
So Bob is the principal, the DAO is the agent.
I would say that a principal-agent relationship has not been formed in this case.
Yeah, that's a good point.
Yeah.
Has not been what?
Formed?
Hasn't been established.
It has not been formed. Okay. Well, then we can't do a agency law analysis if there's not one of those. But why don't we? Well, how about just a contract law analysis?
Why hasn't it been formed? I don't get that.
Brandon, what did you say?
Oh, I said, why hasn't it been formed? I didn't get that.
Because, I mean, from my non-legal perspective, if a DAO did not vote on such proposal, it just means that they did not enter into an agreement in the first place. So, like, there can be, let's say that since the DAO's attention is limited, there can be 100,000 proposals, and just because they made the proposals doesn't mean that the DAO is the agent for those principles. So it's only the principle when the DAO approves entering into, I guess, an agency relationship, then they should have some sort of liability in executing the premise of the proposal.
That would usually be the case if it's a contractual relationship. We talk about contract, so I'm not sure about US agency law, whether it's the same.
Okay.
That's a question.
Awesome. Okay, thank you. Okay, does anyone have any more thoughts about E before I move that back to D?
Yeah, I don't see that there's any basis for liability at all, unless the DAO promised that it would decide by a certain time or something, or like if they breach some promise or duty.
Yeah, exactly. That's the point.
Definitely. So, with that in mind, what would, if we were constructing this DAO in real life, what would be some, important factors to make sure we consider so that we don't run into that problem?
Well, one thing is to make it clear to everybody before they submit a proposal that, we may say yes, no, or take no action on your proposal, and we bear no liability. And then, honestly, I think you might, as a DAO, also want to make clear, you might want to make a click-through of some kind so that the people that submit a proposal agree contractually to your terms. And then one of the terms, honestly, should be, we are not your agent for purposes of this transaction.
Yeah.
That absolutely eliminates an agency law analysis.
Totally. Nice. Okay. Well, that has been confirmed by Sokka as a valid behavioral approach. Okay. So moving back up to D.
So Kem, this is not legal advice, but talk to a lawyer and think about getting that stuff in there so that something useful for you comes out of the session.
Useful out of what?
this otherwise non-useful discussion. Just kidding.
It's interesting.
Yeah, definitely talk to lawyers in their official capacity. Okay, so permutation D, the functions involved are number 4, the logistics company ships. So it's this part at the very bottom where the Espresso book machine has printed and logistics partner, the approval has passed so that the action can start happening of Espresso book machine printing. Now logistics partner, Charlie Corp is the logistics partner, so it needs to ship. So the one we have there, the publication is initiated, meaning curators have voted to approve the proposal, and the order was sent to the logistics partner, Charlie Corp, to ship by August 31st. Charlie Corp in turn accidentally selects the shipping date at the end of September instead of August, and they're like, calendar app thing, delaying shipment long past the date Bob was promised. So, on the Dow's end, then, everything was done right. Like, the voting happened, it was passed to the Espresso book machine, then, it was passed down the supply chain to the logistics partner. But then on the logistics partner end, then it messed up. So the thing that I was trying to get at here is, the logistics partner is a third party, but insofar as the logistics partner is, part of this inextricable part of the process of actually delivering on the contract of getting the book out by this particular date, then is the logistics company kind of also, an agent of the DAO in a way. Like, the logistics partner, I would think would have, a duty to deliver correctly, like this book that was ordered through them. So does that mean that, because the DAO contracts with the logistics partner to perform this function, then because the performance of the function, fell apart on the logistics partner side, then, is the DAO still liable for, the fact that they were supposed to deliver on that time, even though it wasn't the actions within the DAO, but instead a contractor of the DAO that messed up?
Here I would say it was the point I was kind of making to you guys in the box, which is it depends on what is the legal interfacing system. Yeah. So did they sign a contract that stipulates that it's applicable in a certain jurisdiction? Is it referring to a decentralized arbitration scheme? Is it a system where people are completely staking and there's an escrow and then they only release it after? So it really depends on, again, the notion of jurisdiction, wherever there is some liability there or not.
Definitely.
So if you sort of say that, if you kind of fuzz some of that detail and try to apply an agency law analysis, if you said the principal was the DAO and the agent was the logistics company that messed up, and the third party was whomever, the funny thing is, I guess the third party you could say was the the reading public, or you'd have to think about who the third party was, but it'd have to be someone that was waiting for the book and who was harmed by the fact that it wasn't there. So, I don't know, the bookstores or the adoring fans or whatever. Then probably at the highest level of abstraction, you can attribute the acts of the agent to the principal. And so if the DAO thought it was such a great idea to choose this logistics company, that was their choice. They were in the best position to avoid the loss, and they can be held responsible under agency law for the acts of their agent. In fact, that's the whole point of agency law, is to draw a direct connection between the principal and the agent. And to figure out the lines that they're operating within. And then if you start thinking about defenses, you can wonder, was there some supervening kind of cause, or was it outside of a contract term, or maybe was the agent doing something? Well, you didn't say this in the facts, but if the agent was way out of the scope of its authority, and to Silke's point, an ordinary reasonable third party would have known that, then maybe there's they break the liability chain. But for the most part, I think the basic analysis is the principal would be held responsible for the negligence of the logistics agent in not providing the service.
Yeah.
But doesn't that? I've got a question.
Wait, what?
I've got a question. Doesn't that depend?
Sokka was just making a point that does this sneezing? I'm glad to bless you. Wait, what was your point? And then from Brendan.
Following on what Dazzle said, in that case, you would then be able to, like the DAO would then be able to sue the publishing company in regress, basically. Like, well, they've been held liable, and then they would look at their contractual relationship with the publisher, or what was it, logistics company, and they would then be able to sue for whatever loss they had.
Totally.
Yeah, exactly. And just to play it through even more realistically, so that we have all the pieces connected, you've got a third party that's aggrieved in this case. So like we were depending on the book, but our birthday party didn't work because we didn't have the books, or we lost some money in our business. They sue the principal, the DAO, let's say, for not getting me the book. And then the DAO like does a cross claim or something like that or counterclaim or a cross claim to their agent, who was the publishing company, to say like, hey, it was your fault. So I just got sued for $10 million. You owe me $10 million to pay off the suit because you're the one that messed up. And and so it kind of, I think that's how the chain goes. But to really complete these things in the scenario, you have to kind of be a little more explicit about what went wrong, who was harmed, and who can they lay their hands on, basically.
I was wrong, right? Because he didn't get his book.
I mean, Charlie was wrong because like they hired.
No, Charlie. What is that guy called?
Oh, Bob.
Sorry, Bob was wrong.
What?
Oh, harmed, not wrong. Oh, yeah.
Wronged, yeah.
Yeah. So
because he didn't get his,
Shipment
famous at the conference.
Yeah, definitely. It's like it's like, even though, his book is terrible, so maybe everyone else was better off that it like didn't get distributed.
Or it's illegal.
Yeah. Yeah. So, the only person who's actually, well, also the intern was probably harmed because they made like a terrible error.
Daza.
Yes.
Yeah. Derivative in every way. Yeah.
Daz, to go back to your circular point, if the publisher, if the principal had a clause that said, I'm not going to be liable for your unhappy child at his birthday party, then there wouldn't be an issue, right?
Yeah, that would be one way to reduce liability. If you can get a direct disclaimer of liability that the other party agreed to, that can sometimes do it. And, in the contract laws, once we finish this agency law stuff, we should probably spend some deep time on contract law where most of the action is. But there's a lot of ways to then wheedle around disclaimers and things like that. But like that is a very important and interesting analysis. And it kind of gets, I think, the DAO stuff to the place where it needs to get to, which is thinking through like what should be the standard clauses and who are the people that should be agreeing to what and when in the whole life cycle of the transactions. So I think as usual, you're ahead of your time, Brendan. And like, I think you're asking exactly the right question for tomorrow, which is, what kind of disclaimers can you put in there? What are the liability limits? What kind of damages caps, and what is the chain of contractual privity, basically, that it makes sense for the innovation and the new relationships made possible by the DAOs.
Yeah, and I just wanted to add real quick, I think once I started identifying, which functions produce which, kind of outcomes, we can start coming up with like a standard set of disclaimers that could be used for that series of functions. So if it's functions related to like the voting mechanism, or functions related to, if it's like the way that the onboarding takes place, you can start like coming up with like templates that are specifically meant for DAOs, such that they're like keeping the liability at a minimum.
Amen.
Definitely. Okay,
And
so on
that-
that note, let's move to the final permutation if everyone is down, which is F. So this is just you know, one that is very trivial compared to the other, but I wanted to make sure that we got all the authorized DAO functions, or not all of them, because we left off the ones about fundraising, because that's an entirely different discussion that I think we'll probably get into securities, and we maybe in the future we can go there. But in terms of the authorized DAO oops, I just realized I'm not on the screen sharing one. In terms of the authorized DAO functions that you know, we're covering here, then we also wanted to say, you know, where does something go wrong with onboarding new participants? So here we have, you know, when Bob submitted his proposal and deposit, the DAO's onboarding manager informed him that he would have to pay the full amount before shipping and printing could start. Information also clearly stated in the proposal contract, you know, that like the smart contract that had to be, you know, to activate, you know, the printing and shipping to start. So, you know, if you remember, like there's this proposal contract and the proposal has passed, and we said, you know, we're just like, for the sake of this, when the, in order for, you know, it to go from proposal passing to actually being printed by the espresso book machine, then, you know, he has to pay the full amount. So the, you know, there's enough funds for the espresso book machine to run. This is where fundraising would come in if we were going there. But, you know, so he understood the stipulation when he was signing, and the, you know, he was waiting for more donors to come through before paying the full amount. So basically, you know, he wanted to start the process and know that, you know, the publisher that he could use to publish his book is the espresso book machine, because he had been, you know, trying to figure out what publisher to use. And so he knew that that had been passed, but then, you know, since in order for the process to actually begin of printing, then he would need to be able to pay the full amount. You know, he thought he would be able to get more donors to actually pay for it. Then, you know, by mid-August, he accepts that like no one else is interested in funding it. So he has to choose between, you know, canceling the order, which would cause him to lose the deposit, or just funding, you know, the 25 books himself. But by that point of mid-August, you know, the event is on, oh no. Okay, yeah, the event, you know, is on August 31st. So it's like, you know, he had, sorry? Oh no, did it sign off? Oh wait, oh, they're still there. Yeah, so basically, you know, he has to choose between like just not getting the book printed at all. But, you know, unlike before where it was, you know, the fault of the logistics partner not printing it in time, now it's his fault. And, you know, he was onboarded to know that he had to do all of these steps in order to actually get it printed. So, you know, so I guess this comes into a point where, you know, now, like, and I think this also probably just highlights the fact that it's impossible to really get into an analysis of this without contract law, because, you know, it's like he tries to say that because he wasn't onboarded enough, you know, then they should cover the cost. So like to try to get at this question of like who covers the cost for these different things, if that makes sense.
Is that a question of general terms, and whether the general terms bind or are omnibus?
Yeah.
The terms he had written down.
I don't think so, yeah.
So that would be in the participation agreement of that down.
Definitely.
Which would spell out the thing, I guess. I mean, he has no claim.
Yeah,
If
definitely
it
not.
was drafted properly for the DAO, if the DAO had proper participation in terms, there wouldn't be any claim, because he did not do what the DAO required.
Definitely. I mean, there's also the question of like, was an agency relationship formed at all? Like, is it like that earlier fact pattern where there wasn't actually any agency relationship? Because.
Oh, yeah, I'm sorry. Sorry.
Oh yeah, no. I mean, I don't know. I was asking.
It seems more like a tort kind of contract thing, the way that you did it.
Yeah. And maybe there's some other examples of how onboarding could go wrong as well. So that's probably not, you know, even a good permutation maybe, but, you know, the thing, you know, just to, before we quickly close up, you know, or, you know, open to any questions that anyone has about this. Then I think, what I really wanted to highlight there, oh wait, I'm on the wrong one. What I really, wanted to highlight is how, each, as we mentioned at the beginning, each of the circles is, human behavior that exists to a certain extent off-chain, whereas, each of the square parts is, an autonomous software going forward. And that is like the bonding curve that maybe we could just briefly mention for a few minutes, so it's not like this black box, but like, the fact that each of these different functions, it is involved in initiating or impacting a transaction. And, some of them like onboarding, might come in at like certain points and end up impacting other points. Yeah.
Yeah, and I think just quickly, I think too, like the construction that we used in having all of these roles and functions and apps denoted by shapes and relationships is that what we are like really moving into is kind of like this legal object model where each like different piece of the puzzle has different attributes that are based on not just where it's positioned, but also the specific features that it holds, and those features can help, or those features will necessarily impact, what the legal ramifications are in the event that any of these scenarios that we've gone through kind of blows up.
I'll throw something out there. I think that's a great point, Brian. And this came out in our pre-meeting discussions, and it is along the lines of what we discovered when we were talking about the bonding curve and how there are potentially different players with different roles and rights and obligations that you have along that curve. So I think Beth mentioned in those discussions how it might start off being one set of right holders, and then it moves on to a more of a crowdfunding type of thing later on. But the point here is that these things are dynamic, and at some point, a lot of complexity comes in due to that.
Yeah, the first call we discussed something like this, where like a DAO enters into an agreement, but then like somebody else joins the DAO, and like that agreement's consequences like is affecting this new onboarded person. And then we talked about like there's like an expectation from the new participant that he understands the previous contracts entered into before his or her onboarding. So I think similar thing applies for the player.
Definitely. And also, so we have to get out of here at 7:30, so maybe just like one more statement.
Thanks for putting this together.
Oh, sorry, Sokka has one more thought. No, I really want to know. I want to know.
I want to know.
Yeah, come on.
No, my point on this, and I haven't really looked at this from the agency perspective that much, but these kind of liability relationships, I think they should mainly be, if it's set up properly, it would all be contractual.
Definitely.
And only if it's not set up properly, we might somehow get into this area.
Totally.
If things happen that weren't envisaged in
Yeah.
the contract, and the law which applies to that whatever relationship doesn't take care of it, or that, there's no in the civil. For example, in Germany, it would be the civil code takes a lot of this, lacuna that's not in the contract, and then you would also look at the agency law.
Definitely.
But
well, hopefully we can revisit that and keep iterating on this model and actually testing it IRL. So definitely would love to know, more about that.
I wanted to say something.
To your insight, Silky, the reason why we started doing this was to see if by just running through the fact patterns and different legal frameworks like agency, then contract, could we surface some insights and best practices that would be helpful as people are rolling out the DAOs. And I think every call we've had at least 2 or 3. So to your point, I think by Jove, you've got it. That's exactly what we're trying to do.
Great. Well, this was wonderful.
Awesome. Thanks everybody for being on. This is fun.
Oh yeah, and can you do your meetings other ones like some earlier time, New York time?
Oh yeah, because it's always midnight for us.
It would be amazing for us to participate, but I'm already now tired, so
Yeah.
midnight I'm useless.
From now on, we should say it'll be like this time slot, like the 12 noon time slot, for all these things. Because if we can keep our European partners, this thing is going to be much better.
Definitely. Well, thank you all so much for joining us at lunchtime, and this hopefully was a great discussion. It was really fun planning it and hearing y'all's insights. So,
Great. Thanks a lot.
bye. Good night, Aaron.